Senator Paterson.
Thank you, Mr Acting Deputy President. I'm very pleased to rise to contribute to the debate on the Building and Construction Industry Improving Productivity Bill 2013. And it's pleasing to, again, for the second week in a row on a Monday morning, begin on a positive note, dealing with such a substantive and important piece of legislation. And I hope this week proves as successful for the ABCC bill as last week proved for the Registered Organisations bill. And I commend again Senator Cash for her leadership in this area and her tireless efforts to secure the government's key election commitments in this area. I'll note up front that I listened carefully to the contribution of Senator Lyons and particularly her comments about safety, and I congratulate her for taking these issues as seriously as she does. And I just flagged that later on in my remarks I will address some of the criticisms of the government that she made and respond to some of those issues. But I thought it might be more helpful to begin this morning by just talking about exactly what this bill seeks to do, what it is seeking to address, and why the government sees this as such an important priority. As many senators will know, in fact I suspect all senators will know, what this bill seeks to do is to restore the Australian Building and Construction Commission, which previously existed between 2005 and 2012. When the previous Labor government abolished the Australian Building and Construction Commission in 2012, what it did was replace it with a much weaker building regulator, the Fair Work Building and Construction Body, known as FWBC. In a couple of key and important areas, the FWBC and the laws that Labor put in place are weaker, and in these following areas. Number one, the maximum penalties for breaching the law were cut by 2/3. That's obviously had a very significant effect on the behaviour and the effect of these laws on construction unions, particularly the CFMEU. Secondly, FWBC has no power to enforce the law when affected parties, for example a building company and a union, have entered into a settlement. So if a union is able to coerce and intimidate a building company into agreeing to a settlement on whatever terms, the FWBC has no power to intervene, even if it's a contravention of the law. Number three, the compulsory powers that the ABCC has were retained, but they're instead subject to a sunset clause that will expire on the 30th of June 2017, and no doubt many in the CFMEU are circling in their calendars that date, looking forward to that day if this Senate does not act on Senator Cash's bill. And fourthly, there is no effective building code to regulate employer conduct, which is also an important matter that must be regulated. So what this bill seeks to do, what the ABCC bill seeks to do, is to firstly restore the penalties to their former level. They were originally recommended in 2003 by the Coal Royal Commission, so we're seeking to return to those recommendations. These penalties will be substantially lower than the equivalent penalties in other equivalent legislation, for example, in the Corporations Act and in the Competition and Consumer Act. So that's the first, restore penalties to their former level. The second is remove the inability for the law to be enforced where private settlements occur. As I mentioned before, if a union is able to coerce a building company into agreeing to a private settlement, the FWBC is not able to enforce the law. That is an extraordinary and unusual circumstance. So if any related civil dispute between an employer and a union are settled, even for a nominal sum, FWBC has no power to bring proceedings or continue any proceedings to enforce the law. This is the equivalent of the police having no power to prosecute a driver for running a red light and causing a crash if the driver reaches a private settlement with the other driver. We would never tolerate this in other areas of law. Number three, this bill seeks to retain the compulsory evidence-gathering powers that Labor retained, but which were due to sunset in 2017. That's a very important measure. And number four, to introduce an effective building code to be made as a legislative instrument under the Act. This will impose a range of requirements on employers in the building industry. It will not apply to unions or employees. These requirements must be met by an employer that wishes to tender for Commonwealth-funded building work. These include compliance with all relevant laws, doesn't seem like a shocking requirement or unreasonable requirement to me, such as workplace, taxation, safety, immigration, etc. Any employer who breaches any of these legal requirements, for example by underpaying employees, an important matter that Senator Lyons raised, by breaching safety requirements, a concern to this government as well as those opposite, or employing staff who don't have valid work visas, a problem which I think all of us agree needs to be addressed, risk being declared ineligible to work on projects covered by the Commonwealth. I think that's an entirely appropriate measure given the taxpayers' money is involved. Importantly, the code will also protect smaller subcontractors from unfair practices by head contractors. I think that's a worthy and sensible initiative. I want to commend to the Senate an article that was published in the Financial Review last week, and it was written by Gerard Phillips, who is a partner in the Labour and Employment Workplace Relations Safety Group at K&L Gates, which is a global law firm. He's gone through and analysed, I think, in a reasonable and dispassionate way, the key measures of the bill, and I wanted to share with the Senate his conclusion about some of the aspects of the bill. I won't read the entirety of the article, but just some key aspects of it. It appeared on the 22nd of November in the Financial Review, and I quote, "The bill proposes expanding the definition of building work to cover transport and supply to building sites. This is a necessary and desirable measure because, as history has shown, the Construction, Forestry, Manufacturing and Energy Union, CFMEU, has often pursued suppliers and transport companies to put commercial pressure on a builder. By choking off its supply line and pressuring innocent third parties, the CFMEU's tactic is to cause a collapse in the builder's resistance in enterprise agreement negotiations." He goes on to say how any member of parliament could think that a provision dealing with this deliberate behaviour is a bad thing defies belief, and I agree. Analysing another aspect of the bill, the increased penalties, he refers to a judgment by Justice Christopher Jessup, in which he recently states, "The CFMEU's record of non-compliance with legislation of this kind has now become notorious. That record ought to be an embarrassment to the trade union movement. Quite obviously, over the years, the CFMEU has shown a strong disinclination to modify its business model in order to comply with the law." Now, as Mr Phillips says, these are very strong words for a judge, and in the clearest terms possible, he is making the case out for higher penalties. Quite simply, the current regime of penalties, set by the former Labor government, is no deterrent at all to the CFMEU. Breaking the laws of this land has simply been priced by the CFMEU as the cost of doing business. Given that the penalties are obviously no deterrent, they need to be increased to a level where observance of the law becomes the more desirable alternative. I think that's an entirely reasonable point, and as I said, I commend that analysis by Mr Phillips in the Financial Review to the Senate. What this bill seeks to address is the problem which has clearly been identified by two Royal Commissions now, by extensive public commentary and media reporting in the building and construction industry. There are now, as we all know, more than 100 CFMEU officials before the courts. That's an extraordinary number. If there was any other organisation in our society that had more than 100 of its members before the courts, I think we would regard that organisation as one that is totally rogue, totally out of control, and needing action to address it. Clearly, there's something systemically wrong in this industry. The courts have imposed more than $8 million of fines for the CFMEU's law-breaking. That's even under the revised lower maximum fines introduced by the previous government. But sadly, it is clear, and it becomes clearer every day, that this does not deter the CFMEU. If the penalties are not enough to deter law-breaking, then surely the penalties need to be increased. The Masters Builders Australia has estimated that infrastructure, such as schools, hospitals and roads, cost taxpayers up to 30% more because of industrial action and delays at building sites. And I'm going to come back to that point later on. Large building contractors are currently free to lock out smaller contractors in the industry by discriminating against those that do not have a particular type of EBA favoured by the large contractor and or by the unions. As we know, there is from time to time in this industry a cosy relationship between large unions and large construction companies that is to the detriment of small and medium-sized firms in this industry. Big unions and big employers do collude and they do lock out smaller players from building sites. Now, the ABCC was abolished by Mr Shorten in 2012, and the rate of disputes in the construction sector has increased by 40%. In all other industries, the rate of industrial disputes has declined by 33%. So the building and construction industry has become spectacularly less harmonious, a less efficient industry as a result of the change of laws. One really clear piece of evidence that there's a cultural problem in the industry is that the participation of women in the industry has declined in the last 2 decades, against the trend in most other industries. How can we attract more women to this industry if we can't change the culture? And this is an issue that I know that many senators have genuine and sincere concerns about, and I would encourage them to apply those genuine and sincere concerns in other policy areas, in other spaces of the economy, to the construction industry. As I foreshadowed earlier, Senator Lyons made a number of comments about safety, and it was certainly sobering to listen to her and to listen to the cases of workplace deaths that have recently occurred. And I can only concur with Senator Lyons that they are incredibly troubling, and I know they weigh heavily on the minds of all senators, not just on that side of the chamber, but on this side too. She's absolutely right to say that we should be pursuing a goal of 0 deaths in the construction industry. In fact, in all industries, no worker in any workplace should be injured, no worker on any worksite should be killed. And I certainly support the sentiments of her comments. But of course, this bill, the ABCC bill, does not make any changes to workplace safety law. Nothing in this bill changes workplace safety law in any way. It does not prevent legitimate safety issues being raised or addressed by either employees or unions, or particularly by health and safety regulators who have the most important responsibility to ensure that our workplaces in Australia are safe. And Senator Lyons did foreshadow and mentioned one of the encouraging things in recent times has been the decline of construction industry deaths. She's right to say that a decline is only a start and that we hope to get to 0, and I concur with that. But nonetheless, I'm pleased that there has been a decline. The number of deaths per 100,000 workers in 2003 was 5.8, and that's now dropped to 3 per 100,000 workers by 2014, which is the most recent figures available. That's pleasing, and I hope that continues, and I see no reason, and I've heard no evidence, that this bill will adversely impact that trend in any way. What it seems to come down to from those opposite, and I'd be happy to be corrected if I'm wrong, but that anything which reigns in the CFMEU at all, anything which seeks to ensure that the CFMEU is compliant with the law, will somehow, in some way, mean that workplaces are less safe. What that is tantamount to arguing is that the CFMEU can't do its job without breaking the law, that it's okay for the CFMEU to break the law because it's got a higher end in mind, that the means are justified by the ends, and that is a really strange and unusual logic. Unfortunately, we know that the CFMEU has a track record of misusing safety concerns as a cloak for its other activities. And there was a particular case which I want to refer to, which I think illustrates this very powerfully. Of course, the CFMEU has an important role in ensuring safety, but any time that it uses the thin veil of safety to achieve its own objectives, it undermines its important role in upholding safety, and it is understandable why people have become cynical about the CFMEU's statements about safety when it engages in conduct like this. I'll shortly be quoting from a media release from the FWBC from the 9th of July 2014, and it has 2 important features. One is it has quotes from an important court case by Judge Burnett, and it also talks about the conduct of the CFMEU in a particular dispute. Federal Circuit Court Judge Burnett has said the actions of CFMEU officials Kane Pearson, Joseph Miles and Shane Treadaway on a Brisbane construction site represent a gross failure of corporate governance on the part of the CFMEU and its affiliates. Again, as we've seen in other cases, this is an extraordinarily damning indictment for a judge to make about the CFMEU. In February this year, Judge Burnett penalised the CFMEU and the 3 men a total of $38,500 for hindering, obstructing and acting in an improper manner on a Brisbane construction site on the 11th of February 2010. Now, the media release goes on to quote some of the phrases and sentences that Mr Pearson and Mr Miles engaged in on the site. I'm not going to even attempt to read them out because I would have to stand here and bleep myself continuously, such is the nature of the language, but I think it's language which all of us are familiar with because we've heard it in so many hearings and courts over the years. But one of the key things that was interesting about this is that Mr Miles, Mr Treadway and Mr Pearson said that they need to access this site using their right of entry powers for safety reasons. But Mr Treadway brought with him an FPOS machine and was seen walking around the work site with an FPOS machine. Now, I acknowledge I've never worked on a construction site and I'm no expert in construction safety, but I'm not aware of any purpose that an FPOS machine could be used for to assist safety. I am aware of other purposes that FPOS machines could be used for. It could be used for taking payments, for example. It could be used for taking payment of union dues, for example. It could be used to sign up on the spot any workers on that site who are not union members and give them a speedy way of doing so. But I cannot see how in any way that relates to safety. And that is sadly one of many pieces of evidence that the CFMEU has abused these laws. I want to turn now to the important matter of productivity and the economic impact of this bill and the importance of this industry. As I've spoken about before, and other senators have too, the rate of industrial action in the construction sector is far higher than other industries. In fact, the latest ABS data for the June quarter shows that it is 9 times higher than the average across all industries, and this obviously has an impact on productivity. Currently, of all the days lost in the economy to industrial disputes, 2 out of 3 of them are in the construction industry, and that's despite the fact that obviously the construction industry only employs a small proportion of Australians, not the vast majority. Infrastructure, as I've said before, like schools and hospitals and roads, will cost taxpayers up to 30% more because of the extraordinary amount of working days lost due to industrial action at building sites. And this is what the ABCC seeks to address. The construction industry is our 3rd largest industry. It contributes 8% of GDP. It employs nearly 1.1 million Australians, and there are more than 300,000 small businesses in the building industry. There was an interesting article published in The Australian last week by Ewan Hannon, which detailed the massive total cost of this disruption and disputation by the CFMEU and the impact it has on our economy. A total of $100 billion worth of projects have in some ways been delayed or disrupted by CFMEU activity. Some that have already been before the courts, where the CFMEU has been found guilty of workplace law breaches, and some which are coming up before the courts in the coming months. The Prime Minister was interviewed about this very topic on Melbourne radio on Friday with Neil Mitchell, and he highlighted particularly concern to me as a Victorian senator how serious this impact has been on my home state. He said, and I quote, "Let me give you some good Victorian examples. There are 270,000 Victorians working in the construction industry. There are 22 Victorian CFMEU representatives before the courts for breaching industrial law. In Victoria over the last decade, the CFMEU has been fined $4.3 million, the highest level in any state. And they've been found to be in breach of the law on building sites in Victoria, including a project for 58 schools, road and rail projects, Mitcham and Rooks road rail separation, Southern Link upgrade, the Florey Neuroscience Institute at Heidelberg, the Simpson Army Barracks, the Melbourne Institute of Technology. I mean, the CFMEU's lawlessness in Victoria is so well known. Now, if we can get the rule of law reimposed, restored in the building sector, that will increase productivity. It'll increase the ability of people to work in the industry because they won't have to get past the union being able to dictate which subcontractor, which tiling contractor, for example, can get a start. And of course it will, by reducing industrial lawlessness, you'll reduce the costs of these on jobs. That's a very important point by the Prime Minister, and in my remaining minute I just want to highlight a couple of the cases in my home state of Victoria that have been adversely impacted by the CFMEU, which I hope with the restoration of the ABCC won't be allowed to happen again. One which the Prime Minister referred to is the Mitcham and Rooks road rail separation and station upgrade project. A federal court judge has condemned the CFMEU for a pattern of contravention of workplace laws. In reviewing a schedule of the CFMEU's previous contraventions, Justice Jessup found it had painted a depressing picture which bespeaks an organisational culture in which contraventions of the law have become normalised. Justice Jessop's comments come as he penalised the Victorian CFMEU $48,750 and its official Joseph Miles $6,375 for unlawful conduct at the $140 million Mitcham and Rooks Road Rail separation and station upgrade project. This is just one of the many examples of the way in which taxpayers and citizens are having good services, good infrastructure delayed or denied to them because of the militant behaviour of the CFMEU. And it is yet one more example why the restoration of the ABCC is necessary.